Good afternoon. It's Tuesday, November 25th, and we need to talk about what is happening in asylum law. The government, or ICE, has taken the position to reinstate Asylum Cooperative Agreements, or ACAs, as many practitioners will call them. These are safe third country agreements. And basically, first of all, this is being applied across the board, not just recent arrivals, and it applies to anybody who arrived at a port of entry in the United States or entered or attempted to enter the U.S. at a port of entry on or after November 2019, which means it's being applied retroactively. This includes families with children, and you do not need to have passed through a safe third country in order for this to apply. Essentially, the way the regulations are written, anybody who sought asylum or seeks asylum in the U.S. after November 19th, 2019 could have their case thrown out of immigration court, and they need to seek first asylum in a safe third country. In particular, right now, we're seeing cases being pre-termitted or thrown out and using Honduras as our safe third country. What is happening is that ICE attorneys, so this means people entered the United States 2020, sought asylum, did everything the right way. They're in removal proceedings. They're going to defend their case. And now ICE OPLA is choosing to ask judges to pre-termit or essentially decide asylum cases prior to the actual hearing date based on the fact that the person did not first seek asylum in a safe third country. So people are never able to present their asylum claims in court to defend themselves. And again, this is being applied retroactively. So at the time, maybe you've done everything the correct way. You entered with CBP1 even. They're going to argue that this applies to parolees. You established a legitimate fear of returning to your home country. You've been waiting for your date this entire time, and all of a sudden, the government can file a motion, or even sua sponte, not file a motion, just in court, say, hey, judge, we want to pre-termit. We don't even want to hear this on the merits of the asylum because you need to throw it out because this individual did not seek asylum in a safe third country beforehand. This, I think, is going to be challenged at a constitutional level, but until it is going to affect thousands, if not hundreds of thousands of people and families who have been patiently waiting to have their asylum claims heard, in court. We have reports from all over the country that practitioners are seeing this. And again, it's not exclusive to just single men. It's applying to families, women. It is not being exclusively applied to any, group in particular. So if you know somebody seeking asylum who entered after 2019, it is really important to brief this issue in advance of their next court date. I know that that's what we're doing in-house to make sure that the government doesn't have grounds to stand on, or hopefully you have an argument in response, or there's other form of relief available for your client to beat these arguments, because it's our understanding that immigration judges are granting the government's requests and they are pre-termitting. In other words, they are kind of dismissing the asylum claims before even hearing them.